Okay, we're going to be discussing Chapter 4, uh, Criminal Procedures. Okay, um, the essential question here is what are the rights of people when they've been arrested? In our country, remember, we have our citizens are afforded rights so that you are innocent until you are proven guilty. You are not automatically assumed to be guilty. You know, whether or not you believe that to be true of our legal system, that's that's a different story, but that is the way that our founders set up our legal system. Okay? So in this country, suspected people have rights. This keeps the government from having too much power. This keeps us from having people be falsely imprisoned. Now, are you aware of Guantanamo Bay? Have you heard of um, that location or heard of that name, Guantanamo Bay or Gitmo? Anyone? Yes, you've heard of Guantanamo Bay. What is Guantanamo Bay? Yes, okay. Um, it is a prisoner of war camp, okay, where we have what we call detainees, prisoners of war, people that we are holding for questioning. We are keeping them because we don't have any evidence against them, okay, yet, but we have suspicion, reason to believe that they have done something wrong or might have information. Now, are these are not citizens of our country. Okay, so therefore they don't have the rights that our citizens have. But we as a country are holding them in these conditions, which are questionable conditions. Okay, and we are doing questioning, and it's kind of an ambiguous, it's a gray area as to whether or not it is legal to do what we are doing. So our citizens would never be held in that way. These people have been there, some of them for years, and have never been formally accused of a crime. They don't know why they're there necessarily. Okay, they've been subject to torturous conditions, some of them. Um, so that would never happen to a citizen of the United States. You must be alerted when you are placed under arrest. You are told what it is you are being placed under arrest for, the reason. And when um, you have your Miranda rights, which means you have the right to remain silent. You do not have to testify against yourself. Our government, our police force cannot torture you to get you to speak. We can't do that. Now in Guantanamo Bay, it's a little different. Okay, but the police couldn't make Kiara talk by waterboarding her. Okay, so you have the right to remain silent. You also have the right to an attorney. Right? Again, in Guantanamo Bay, not necessarily the case. And if you are arrested abroad, that is again not the case. Okay, so you want to be aware of that. All right, so this is just I don't know that this is the actual conditions, but this would represent the conditions um, that might be seen. Okay, the rights of the accused. First, we have due process. These are fair procedures during an investigation, and the right to a trial. Okay. Criminal defendants cannot be forced to testify against themselves. So we have the right to remain silent. That is one of the Miranda rights that are read to you when you are placed under arrest. You have the right to remain silent. Anything you say can and will be used against you in a court of law. Okay, so you do not have to talk. it it has been said that it is generally better for a defendant to remain silent until an attorney is present. Okay? No unreasonable search and seizure. They must have some kind of probable cause to search the grounds, to search your home, to search your car, to search your person. And the right to remain, the right to an attorney is a Miranda right. If you cannot afford an attorney, one will be provided for you. That is a right of our country. Free legal representation. Did you all get that? Okay. Jay-Z was right with regards to a search and seizure. Okay, when you are pulled over, do you know what I'm talking about? You ever heard the problem? 99 problems? Okay. My glove box is locked, so is the trunk in the back. If you want to search, you're going to need a warrant for that. Okay. He's correct. If it is locked and there is no probable cause to search it, he cannot, that the police officer cannot look in those areas. Okay. Now, if the police officer wants to call for a drug dog, and that's what's in question here, the drug dog could potentially sniff out marijuana or other narcotics, and then that would give probable cause for them to then search. But the police officer can't just say, you look like you probably have drugs. Okay, now, if they do that, that is illegal. That is an illegal search and seizure, and then that is thrown out. All right, so here's our little example. This security guard is saying, I want to look at your luggage. And she's saying, are you asking to look at your luggage, or are you ordering me? She doesn't consent to her luggage being searched. And he's saying, we're asking you to cooperate. We have a drug problem. So it's standard procedure. You don't want to hold everybody up, do you? Because if you make us, we're going to go get the drug dogs. But if you just let me look in your luggage, then we won't have to worry about it. So he's coercing her into showing her luggage. Now, if she, at that point, opens up her luggage and allows it to happen, and then they find drugs, she has consented to that search, and then it's questionable. Okay? So he cannot, but she could also go back and say whether that he had coerced her into allowing the search. Okay? Which is not allowed. She said she did not consent to the search. All right. Probable cause. This is a reasonable ground for belief. Okay? It is what is reasonable. Now, there is a definition of the word reasonable, a legal definition. Because what you think is reasonable and what I think is reasonable and what Mr. Fox in the front office thinks is reasonable, they might be very different things. Okay? I see the way y'all dress. You apparently think that's reasonable. Sometimes I'm wondering. Okay? But we have a definition of what is appropriate attire, and that is available for you in our what's it called, our handbook. Okay, so that you are aware of what our expectations are and that kind of thing. Same thing here. So reasonable ground for belief. On page 71, there is a what's your verdict? Okay. Does somebody want to read that for me? Hello. Here.
Hmm. During a routine traffic stop of a small truck for speeding, an officer became suspicious of the cargo the truck contained due to a smell coming from inside. When his request to search the truck was refused, the officer radioed for the assistance of a drug dog. Unfortunately, the dog was unavailable. Finally, he ordered the driver to open the cargo area. When the driver did so, the officer found more than a ton of marijuana. At trial, the defense attorney maintained that it was an illegal search and seizure and that the marijuana should not be allowed to be used as evidence.
Okay. So the question is, um, the police did not, where they were not able to obtain a drug dog. He searched anyway based on his probable cause. Okay, his suspicion that he could in fact smell marijuana. And then on upon searching, he found marijuana. So at trial, they said that was not um, considered acceptable probable cause. Are they correct? What do you think? The answer is on page 71 in the probable cause section. Well, he smelled it and he found it, but was it legal? If they had a warrant, but they did not.
Even though the dog was unavailable, they should have at least succeeded for it. But if he couldn't have, then I believe that they could legally do it since there is no warrant at all.
Correct. Okay. It was an illegal search. Okay. A dog's sense of smell is much more keen than a human. It will be illegal to search without the presence of a drug dog or a warrant. So what they did, continuing with the search without a warrant, was illegal. Okay, so even though in that case, even though all this marijuana was found, um, that case would have had to have been thrown out. Now, when they call for a drug dog, generally they will make you wait until a drug dog can be available, as long as it's within a reasonable time. It can't be, couldn't make you wait a day, but they will make you wait for as long as it would take to get um, the drug dog to come. Got it? Okay. So the term beyond a reasonable doubt, this is the burden of proof. Okay, the defense must only find sufficient evidence to logically indicate that the defendant did not commit the crime. They do not have to prove it. They just have to give enough evidence to suggest that it probably didn't happen like that. Okay? The burden of proof falls on the prosecution, who must prove that the defendant did commit the crime. Okay? This is why we say you are innocent until you are proven guilty. In the case of Casey Anthony, okay, the mother who was accused of murdering her 3-year-old daughter, okay, the the burden of proof again was on the prosecution. They presented all kinds of evidence, but the defense presented a case. They presented an alternate theory to what happened. They suggested that the little girl drowned in the swimming pool, and that then the father, Casey Anthony, or I guess the grandfather, um, I think they suggested that he actually removed the little girl and buried her. So they had this opposite, this different theory. It was enough to suggest that it could have happened that way, and they could not prove beyond a reasonable doubt. Therefore, Casey Anthony was acquitted of the crime. So all of the other evidence did not outweigh the reasonable doubt here, and she was acquitted. She was found not guilty, okay, of this crime of murder of her child. Who what? So she was released. Yeah, she's free. Okay, and they never did. No one has served. No one has been found guilty of the murder. They just, but what they did was they just suggested enough reasonable doubt that it didn't happen the way the defense or the way the prosecution was suggesting. Um, Even though they had Google searches for chloroform poisoning, and they found duct tape on the daughter's face on her remains, her skeletal remains. So they had all kinds of evidence, but when they put it all together, it was not enough to convict her. So she was released. Okay. Well, that was up to the jury. That's what the jury found. So here is our example of our levels of proof. Okay, now this is legalese. Okay, so we have no evidence. If there's no trace of evidence whatsoever, the person is found not guilty. If there's what's called a scintilla, okay, so a little bit, a scintilla of evidence, any evidence at all, even the smallest measurable evidence, okay, they're still not guilty. Okay, reasonable suspicion should be based on specific or particular facts, not based on a hunch. Okay, so that comes down to our profiling of people. You can't say, you look like you probably have, an unregistered firearm in your pocket. I think I'm going to search you. I'm not allowed to do that. You're not allowed to do that. That's a hunch. Okay, probable cause, reasonable and trustworthy information. If Tyler goes to the office and says, hey, I saw Carla, she's got a big bag of weed in her book bag, okay, and then that is a reasonable suspicion, they might search Carla. I don't know. You never know. Okay, um, and then we have preponderance, the greater weight or amount of evidence. Okay, clear and convincing, a firm belief that the allegations are true, and reasonable doubt. And then we get all the way to the top. We have to go beyond all of these levels of evidence to prove beyond a reasonable doubt that the person is guilty. Okay, so the point of this display is to show you it is not easy to prove that a person has committed a crime. Okay, the burden is on the state. So although there is an idea that the government sometimes can strong arm, you know, criminals and put innocent people in jail, it does not happen as often as we seem to believe or people seem to believe. Now, that being said, a day that one innocent person spends in jail, that's really unfortunate. Okay, if a person truly did not commit a crime and they are serving time in jail, they've been convicted for a crime. That's really, really a terrible travesty of justice. So, but that's why it's so difficult to prove that a person did in fact. Yeah, they can sue the government. They can sue, but it's hard to say that any amount of money would make up for the years that you would have lost for being falsely accused and imprisoned. Some people do die in jail, yeah. It doesn't happen very often, truly. And double jeopardy means once they've been found not guilty, they cannot be convicted of the crime again. So Casey Anthony, we could find out tomorrow that she did. We could get a video of her doing it. Okay, we could have the most evidence, a video of her doing it, and a signed confession and everything else, and we still cannot we cannot try her again for the same crime, the crime of murder of her daughter. Well, it's part of our law. Okay. All right, responsibility for criminal conduct of others. Okay, so a person who knowingly aids another in the commission of a crime is guilty of criminal wrongdoing. So in this little diagram here, we have this crazy lady. She's going to stab this lady. And we have this guy holding her arms down. He's not stabbing her. Oh, I didn't mean to go forward. Whoa. Okay, he is not stabbing her. He just looks like he's kind of a goofy guy having a good time. All right, but he would be guilty in this circumstance because he is participating in the commission of this crime. Now, there are different levels. He may not be convicted of first-degree murder, but based on the felony murder rule, which we'll see in a minute, he actually would. But he could be considered, and if he was just outside and he was going to be your getaway driver, he could be considered an accomplice before the fact, accomplice after the fact. Okay, we have what's called aiding and abetting. Okay, if you give money to a criminal and help them get away, that is considered a criminal wrongdoing. Okay, did we all get this? Okay, felony murder. If someone is killed during the commission of a felony, all of the people who participated in the planning and the commission of the crime are guilty of first-degree murder. This is in a majority of the states. There are a few states where this is not the case, but in the majority of the states, including Pennsylvania, we have felony murder. So in our diagram here, we have these two guys. They are coming in and they are committing the crime of robbery, which is a felony. Okay, it is taking of things, money of things of value. Okay, so through threats or violence. And in this case, we see these guys, they have guns in their hands. There's our threat. That's our violence. Okay, so they come in and they are robbing this bank. We have this dude sitting over, or maybe it's a lady sitting here on the bench. We have the teller here, and we have a security guard here. Okay? And we have what we're going to assume is a getaway driver outside. So we have 3 people participating in this crime. Let's say this woman has a heart condition and she drops dead of a heart attack because the stress of this was too much. She just drops to the floor and she's dead. Okay? Nobody shot her. Nobody, tried to kill her. But in the commission of this robbery, she died. Okay? When this crime goes to jail or goes to court, these people would not be only convicted of robbery, they would also be responsible for the death of the woman under the felony murder rule. Because had they not come into the bank, they probably would have gone home that day, gone to the market, gotten something for dinner, gone home, made dinner, watched a little Jeopardy. Okay, but instead she died because they came in and robbed the bank. That's the felony murder rule. Not just these 2 guys. Also, these 2 guys and the guy outside in the car. Okay? The take-home message here for you, Matthew, all of you, is you need to be aware of what's going on. Let's just say, just for pretend, the getaway guy had no idea they were planning to rob the bank. He just was sitting out there in the car. His friends went in, and then they came out and they said, go, 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 go. And now he's a getaway driver. Okay? And he doesn't know that meanwhile, his friends went in there, robbed the bank, killed the lady. And so now he is going to be held responsible for both the felony of robbery and the felony murder. Okay? You have to be careful who you hang out with. Yes.
Did you actually see what happened during this crime?
Did I?
Or did you just find it?
I just found that. I do not think no. I think that they just got money and walked out the door. That's generally what happens. Okay. In most of these situations, that is the protocol is that they are to just hand over the money and not try and fight back. Okay. The liability on the security and everything. We have bank insurance. We don't have life insurance. For a person, you can't replace a person's life. So, okay. So now we're up to defenses to criminal charges. Excuse me. We have two kinds of defenses. We have procedural defenses and substantive defenses. Okay. Procedural. This would be confession under coercion. Okay. Somebody made you confess to a crime in an interrogation. Okay. And so then you would say, it was because of the police misconduct that that was my defense to the crime here. Okay. Ignorance of law, though, is never a defense. It's never a defense. And our little character or cartoon here says, ignorance of law is no excuse. And then he says, well, I didn't know that. Okay. It's funny because, he's playing dumb. Okay. You are required, it is your responsibility to know the laws wherever you are. Okay, now we're not expecting that little tiny minutia details, but there are certain things like robbery and murder and arson that are wrong no matter where you are. Okay? I think the example in the book is a speeding. Um, Someone is traveling on a highway, they're going 70 miles an hour. The police pull them over and say, in this municipality, the speed limit is 50 miles an hour after dark. That's a law. It doesn't matter that he didn't live there and he didn't know it. He's still responsible for, while he's operating the vehicle, he's responsible for knowing the laws of the roads where he's at. Okay, so that would not be a defense. All right, substantive defenses, self-defense, defense of family, and criminal insanity. Okay, we're going to talk about these in a little more detail tomorrow. An immunity, this is when we have a deal that we've made with the prosecution. And so you're not held responsible for the crime. You're not necessarily, you're not saying that you're not responsible. The prosecution's not saying you're not responsible, but you're not going to pay for it in that way. Okay. We will discuss these a little more. We're going to stop here.